under heading for hearing, under order 41/11 of CPC item 25, second appeal, 446 of 2017.
Whatever was heard earlier, please to offer the records.
Yes. Finding with, in connection with which document is perverse?
Madam is also asking to prepare as notes relating to transport. Before I proceed, just two or more things.
Just Schedule B properties under this.
Both the properties are in. Schedule B property or the Buneri land, Buneri Pakas land, Matoi land is also. And the description of those lands are also in Schedule A also. Apart from the RS Khata 79, RS Khata 18, RS Khata 18, CS Khata 17.
You have stated RS Khevat number 12/3, 12/4, 12/5 and 12/6.
Yes, these are
Which is in relation to which property so far as this chart is concerned?
Yes. The Lordship may kindly see plan.
No, we'll see the plane. You
Yes.
just tell us what is the link between this chart and the Schedule B property.
The link should be that so far as the Schedule A is concerned. In the Schedule A, there are descriptions of Matoi and Buneri lands. I will show it.
What is Makoi land?
Yeah. The Lordship may kindly see Buneri Tenues land. 1860. Chota Nagpur Tenures Act 1860. My Lord had passed several judgments on this issue. I remember in my cases also. My Lord, the Act itself says that Buneri shall include tenures mentioned in the preamble as Bharkata, Dalekari, Panay. These are all my Lord.
Mehtoi land.
Matoi
I
is
thought Makoi. Mehtoi land. It belongs exclusively to them and they do not vest.
Yeah.
That's
Buneri, Matoi.
They do not vest.
Dalekari, Bharkata, these are all my Lord.
Their personal properties. So you said that there is some perversity in the judgment.
Yeah.
So perversity in connection with some document. That is why the record was called for. Which document?
Yeah.
And it is relatable to which substantial question?
Yeah. My Lord, both the courts have rejected my claim, my suit rejected, and appeal also affirmed. There are two parts. So may kindly appreciate that the Schedule B property, which comprises of Khevat number 12, 3, 4, 5, 6. These are Matoi land and these are Panoi land. Panai and Matoi Buneri land. There is an admission of the defendant that we are the nearest segments and we are entitled to that. Despite that, the appellate court as well as comprises of the details of the land which is the part of the Khevat is the Schedule B.
Schedule B is a part of Schedule A.
Schedule B is the part, and because Khevat has been given, name of the Khevat has been given, but so far as the lands your lordship is concerned, belonging to different khatas and khatiyas in the name of different persons. Those details we have given, those are the part of the schedule.
My question is very simple.
Yeah.
Is Schedule B a part of Schedule A?
Yes, yes, yes.
So you are concerned with, as of now, you are arguing that Schedule B is Metoi land and Pahnoi land.
Yeah. Bhuneri.
Bhuyari land.
Bhuneri is a genus. Your lordship may say.
Bhuyari land. And therefore these land did not vest with the state.
Will not.
Okay, will not vest. And according to you, there is an admission of the defendants
Yes.
that the plaintiffs are the nearest adherents so far as the recorded persons in connection with Schedule B property are concerned.
Schedule.
So therefore, the title over your property, over the property, that it will devolve upon the plaintiffs.
Yes.
So far as Schedule B is concerned, it could be decided on the basis of admitted facts.
Yes.
This is what you want to say.
Yes. This
Anything else?
Yes. One more thing I would like to say, that both the parties, our case your lordship is that Ella Uram has 3 sons, has 2 sons, Sarva and one another son, Dhuchua. And the third son, your lordship, is the Haul. They say, we say that he was not a biological son, but they say no, he is a biological son, and they both the courts, your lordship. After taking into consideration the commutation nathi and other documents also on record, there are Khatiyans also on record, have concluded that no, he was a biological son.
3 sons.
So 3 sons. And in the written statement also, your lordship, they have pleaded that they are entitled for 1/3. They are entitled for 1/3.
Written statement has been filed on behalf of one of the sons.
Defendant number 1 and 2.
Defendant number 1 and 2.
They are the descendants of the Kilpi around. How do descendants?
I don't get it. Dhulva had 3 sons. All the 3.
Dhela has 3 sons.
Dhela.
One was Shurva, another was Dhuchua, and another son. They say it was Haul. Our case is Laship.
Defendant number 1 and 2 are descendant of whom?
They are the descendants of Haul.
How?
Haul's son Kilpi. Kilpi was son of Haul.
Okay.
To them they belong. So issue of your lordship, my point, your lordship, on the last occasion I have also argued that in this particular case, your lordship, the agnatic relations, your lordship, are being claimed by him also, by me also. But no issue to that effect, your lordship, was framed. That is one of the substantial questions, that is the core issue, your lordship, that I have framed. Lord, may kindly see my substantial questions.
Relationship with Dhuchua. Who is Dhuchua?
Dhuchua is son of Hela. And the property
Son of?
Hela.
This third son of Dhela.
Second son. Third is the Haul.
Dhuchua. Not Dhuchua, Dhuchua.
Yes.
When you say that the relationship is admitted, then under such circumstances, why a issue should be framed?
We had argued, and we had come with a case that he is not a biological son. But when both the courts have come to a finding that he is a biological son.
We'll take that.
Yes. What I am arguing, even if we will take into consideration that at best he is entitled for 1/3. He cannot be entitled for the whole property.
That's right.
And my whole suit could not have been delivered.
So he
These are the
shared.
contradictions. These are the contradictions.
So there was no need to frame any issue in relationship with Dhujwa Urao. Now it stands admitted that Dhela Urao had three sons. One is Surva, other is Dhujwa, and third is Howla. Right?
After the finding of the
After findings
of the Quran.
Right.
But
the court has dismissed the suit without taking into consideration that defendant number 1 and 2 were at best entitled to 1/3 of the property.
yes, yes. And now Surva has also died during the pendency of the suit. So actually the plaintiff, the present plaintiff at the present appellant is only representing that branch.
Which branch? Surva.
Surva.
Appellant is representing whom?
Surva.
Harva. No, appellant is only the Harva.
He was son of one Chamrao, who was the son of Dodo Ram, which belonged earlier they belonged to.
This appellant is representing which branch? Surva, Durva, or Howla? Sarva.
Sarva also had filed this suit itself. But during the pendency of suit, he himself died. And his son was also substituted, he also died. So now, the plaintiff, the surviving plaintiff is the main person, and the defendant number 1 and 2, they are the representing the branch of Pilpi and the Howland.
So where is your question of law in connection with 1/3 share? Because relationship is now not in dispute. Where is your question of law in connection with 1/3 share? And Dhujwa Urao had only daughters.
She had 4 daughters, but
Dhujwa is a lady.
Dhujwa is a male.
Male. He had only daughters.
He had sons also, but she had granddaughters. We have given the genealogy.
No, he had daughters and sons both.
He has sons, and his son has daughters, who were all dead at the time of institution of suit.
Son had also expired.
Son had expired. Granddaughters were there.
Granddaughters were there.
Out of 4, there was only 1, and 3 had already died. That is in the genealogy itself. Regarding that, their admission is also that they have admitted in para 9 of their written statement that we are governed by the tribe.
Tribal of which tribe?
Custom.
And they said that they are to be excluded completely.
Yes, they have said. They have said. That is the point of law which I have also framed. That as because there was an admission, so finding on the issue number 3 cannot claim property of Dhujwa Urao as successor of heirs of daughters of Dhujwa has not been a party purpose in view of the admission of the defendant that they are governed by customary law wherein the daughters are excluded from the inheritance in succession. That is one of the question of law which I have framed.
You tell us, where is the question of law in connection with 1/3?
The question of law which I have framed is with regard to genetic relation.
That is admitted. Now the relationship is admitted. Now relationship is not in dispute.
That is now.
The common ancestor was Dhela.
Yes.
He had 3 sons.
Ma.
Surva, this Dhurva and Howla. So लिख दीजिए spelling, please.
That is specifically is not there. Might not make a claim. Because I was on the genetic relationship itself. But after finding out the concurrent finding of both reports, that he is a biological son, so he get advice, he entitled to that only, and that is in the written statement that is there.
The first appellate court adjudicated the appeal by framing the moot questions as to whether Haudra Urao was the real son of Hilau.
That was the issue.
That was the issue. And whether the defendant number 1 and 2 are the legal heirs and successors of Haudra Urao. So there is not in dispute.
That has given answer in the
And whether the plaintiff is the heir and successor of
Duchwa.
no, Sarva, plaintiff. You see para number 17?
Para number 17.
Of the appellate court judgment.
They have said, my lord, that court has held that failed to prove themselves as legal heirs and successor of
The para number 17
Para number 17.
of the appellate court judgment, internal page 13.
To adjudicate appeal, in my view, moot question are whether the Haudu are the real son and whether the defendant are the legal heirs of Haudu and whether the appellate is the legal successor of Shura. My lord, the finding, your lordship, is at page, your lordship, 25.
No, internal page तो 19 में ही खत्म हो जाता है.
Page 17.
Page 17.
Yeah.
Yes. I hold that the plaintiff failed to prove themselves as legal heirs and successors of Dhujwa.
But on the ground that the legal heirs of it is also a partnership. I will view of the admission.
Plaintiff did not prove the Orav custom by way of proving customary law. Neither he brought the Pahan or head of the customary or community, nor he produced his elders, villagers, or Orav community to prove that the state customary law are not heirs and successors of their father. And Dhujwa Orav died, leaving behind daughters, but the plaintiff did not make it clear what happened to their husbands and children.
But there is an admission in their admission in the written statement. For that only I have filed this substantial question. So that should be kindly see this substantial question. Whether the finding of the learned appellate court on issue number 3 that the plaintiff cannot claim property of Dhujwa Urao as successor and inheritors, heirs or daughters of Dhujwa Urao have not been added as a party further in view of
एक
the
बात
admission.
बताइए, धुजवा plaintiffs claimed to be the descendants of
Sarva,
no, only
Sarva.
Only Sarva.
इनका भी नहीं कर.
Plaintiffs were the legal heirs and successors of Sarva. They claimed to be the legal heirs and successors of Sarva Urao.
Sarva and yes, Sarva.
Only Sarva, तो धुजवा का पार्टी कहाँ से आया?
No, but we are claiming agnetic relations. Agnetic succession.
From Dhujwa.
Because several of the properties of the ship in the Khata covered in the name of the Dhujwa also.
So whether, you see, unless you are the successor of Sarva Urao, you cannot be the successor of Dhujwa Urao.
Yes, I agree with that. But
So is there any finding that you are the successor of Sarva Urao?
My lord,
In absence of that finding, you cannot claim agnetic
yes,
relationship.
yes, I agree to that.
Then-
Your Lordship may kindly see the genealogy first. May kindly see, my lord, page 3 of the trial court judgment. Lashmi, can you see our genealogy Hela Aura? My lord will find.
Yes.
Then my lord will find Sarva Aura. Then
Yes.
Bhuchwa, and then my lord the Howlu.
Yes.
We say that he was brought with the wife with previous. Now my lord, that is not in place. My lord may find, my lord, that Sarva himself had five issues, my lord.
Yes.
Then my lord, he is survived by Ladua and Mangal.
Okay.
And my lord, the next one, your lordship is Chamra and Aham.
Chamra and Howrah. They are
Aham is the plaintiff, my lord. He was
Chamra is, what is the name of father's name of Chamra?
Chamra.
Yes.
Chamra's father's name, your lordship is Sarva. Ladua.
नहीं,
हाँ.
कहाँ से बोल?
सर्वा के बाद नीचे देखा जाए तो लोधवा और
नहीं, सर्वा के बाद लोधवा हो रहा है, मंगल हो रहा है।
नहीं वो उससे पहले टॉप सर्वा डैड के बाद नीचे में देखा जाए लोधवा।
हाँ, वो तो दिख रहा है। ये चमरा उराव के पिताजी का क्या नाम?
चमरा उराव का पिताजी का नाम लोधवा। सर्वा का भी और चमड़ा का, और चमड़ा के लड़का है हम हड़ू।
नहीं, आप बताइए, ये सर्वा उराव लिखे डाइड, उसका डिसेंडेंट आप लिख रहे हैं सर्वा एलाइव।
Here you are plenty.
Okay, he was a plaintiff.
इसका लोधवा भी है।
Just a moment. सर्वा was alive. इनका जब डेथ हुआ तो कौन इनके
जगह पर
कौन आए?
मंगल उराव बना था पार्टी।
मंगल और कौन बना?
मंगल ही बना।
ओनली मंगल बना था, बाकी लोधवा नहीं बना था।
लोधवा नहीं।
He was his full brother.
नहीं बना नहीं।
His full brother.
बना नहीं।
और ये चमड़ा?
चमड़ा डेड था, उसके जगह पर हाउडू शुरू से भी प्लेटिव।
ये चमड़ा का नाम हावड़ू के डिसेंडेंट में कहाँ आ रहा है? आप देखिए, हावड़ू और राव जो सबसे राइट हैंड साइड में है, ठीक है, इनके दो बच्चे दिखा रहे हैं आप।
इनके हम ऊपर में दिखा रहे हैं, एनवायरनमेंट भी है।
ये मंगा उराव एंड जोना एलाइव,
नहीं वो
ये दोनों डिफरेंट हैं।
ये धोचा का जो कि आप खुद पढ़ रहे हैं, हम इसमें सर्वा का पढ़ रहे हैं।
भाई ये तो आप हमको पता है, सर्वा के दो ही बच्चे हैं ना?
दो ही बच्चे हैं, सर्वा और चमड़ा।
सर्वा और राव के दो बच्चे हैं, सर्वा और चमड़ा।
सर्वा और राव के जो बच्चे थे मंगल राव, उनको इसके डेथ
मंगल एंड लोधवा।
हाँ, लेकिन वो पार्टी सिर्फ मंगल ही बने और वो भी डेथ हुई। लेकिन चमड़ा का लड़का जो था वो था ही।
तो चमड़ा के पिताजी का नाम आप हमको इसमें से लिख कर दिखाइए।
ये दोनों में से ऊपर देखा जाए लोधवा।
कहाँ से? ये तो ये
सर्वा और राव के जस्ट नीचे देखा जाए। सर्वा और राव डैड के बाद लोधवा।
नीचे सर्वा और साथ में एलाइव में लिखा है प्लेंटिफ, और उसके बाद लोधवा और राव और मंगल और राव लिखे हैं। ये चमड़ा और राव तो आप अलग से लिखे हैं।
नहीं, ये चमड़ा और राव तो है साथ में, तो हमारे आप जजमेंट पढ़।
ये चमड़ा और राव के पिताजी का नाम आप हमको इसमें दिखाइए कहाँ पर, किसको पिताजी आप बता रहे हैं, बताइए। पेंसिल लीजिए। कौन है इनके पिताजी? सर्वा जब जिंदा थे तो दो उनके बेटे थे, तीसरा बेटा कहाँ से आया?
सर्वा उराव का लड़का था लोधवा, लोधवा का लड़का था सर्वा, और सर्वा और चमड़ा।
ये जीनोलॉजी से तो ऐसा नहीं लग रहा है, भले आप
उतना ही नहीं, उनका जीनोलॉजी भी है।
सर्वा के बेटा थे लोधवा, और मंगल नहीं थे उनके बेटे।
जी, लोधवा का दो बेटा।
कौन था?
सर्वा और चमड़ा।
लोधवा का, सर्वा का बेटा लोधवा, लोधवा का बेटा सर्वा।
हाँ, इसमें ऐसा एक लोग में नाम होता है।
कहाँ से यहाँ, ये आप जीनोलॉजी में कहाँ से बोल रहे हैं?
हम जीनोलॉजी जो लिखे हैं वही हम पढ़।
भाई सर्वा पहले तो आप सर्वा और डाइड लिखे,
हाँ,
राइट?
हाँ।
उसके ठीक नीचे लाइन बनाए।
लोधवा
नहीं, उसके बाद ये लोधवा लिखे, लोधवा के ही बराबर लिखे मंगल,
नहीं, लोधवा के बाद नीचे इसका आया जाएगा, उसके बाद सरुआ एलाई लिखे हैं प्लेटिंग लेफ्ट साइड, राइट में चौड़ा का होगा हाउल जो कि प्लेटिंग, और ये चूंकि खुद प्लेटिंग थे, इनके डेथ के बाद मंगल ने उसमें पार्टी बना,
और सर्वा को लोधवा को आप भूल गए।
लोधवा नहीं बना। इनका भी जो जीनियोलॉजी है, उनका जीनियोलॉजी
तो कौन किसका एग्नेटिक रिलेशनशिप में मान रहे हैं?
हाँ, इसमें सर्वा का जो कि वारिसान है, उसमें लोधवा और मंगल और हाउल तीनों आ जाएंगे, और भुजवा का डेड हो एक्सटिंक्ट हो गया, इसका हमने लिखा है नौरी सुगी मूंगी वो, ये सब चतुआ की ये सब डॉटर।
देखिए कंफ्यूज होके तो हम सब्सटेंशियल क्वेश्चन ऑफ लॉ नहीं करेंगे,
हम तो वहीं से पढ़
बहुत ज्यादा कंफ्यूजन है। आपको बोले थे नोट बना के लाने, आप क्या नोट बना के लेके आए?
तो इस पार्ट पे तो
ये जो आप जीनोलॉजी बोल रहे हैं, इट इज एब्सोल्युटली मिसमैचिंग। आप क्या बताना चाह रहे हैं जीनोलॉजी से? आप क्या बताना चाह रहे हैं? कौन इसमें प्लेटिव था? यू सी द, अभी आप हमको ये लिखा है, जस्ट अ मोमेंट, यू सेड दैट ढेला हेला, इसमें हेला है, कहाँ है हेला?
ये हेला सबसे टॉप में, टॉप।
अच्छा, हेला के तीन बच्चे, ठीक है, सर्वा, दिस एंड
भुजवा,
हाँ ठीक है, ये हो गया,
और
फुल सन्स हो गए, ठीक है। उसके बाद
फर्स्ट जो इसका सन है,
हाँ,
जो इसका
प्लेंटिव्स जो है, दे आर द डिसेंडेंट्स ऑफ सर्वा, डिफेंडेंट्स आर द डिसेंडेंट्स ऑफ
हाउल सबसे कॉर्नर
हावड़ा, ठीक है। स्टेप सन नहीं बोलिए, आप सन ही बोलिए, ठीक है। हावड़ा,
मंगल उराव डिफेंडेंट, जोहन अलाइव डिफेंडेंट, दोनों का डिफेंडेंट नाम आ रहा है,
ओके,
ठीक है।
हाँ,
अब हम हमारा इसमें करना था उनका अपना रिटर्न स्टेटमेंट कि नहीं, हम भी जो है सो 1/3 प्रॉपर्टी के इसमें
हम भी मतलब हूँ, हम
डिफेंडेंट है, पार्ट 13 ऑफ द रिटर्न।
Okay, the defendants who are the descendants of Havra are entitled for 1/3 share.
Entitled, what is the return?
Okay.
हमारा इसमें कहना है कि अगर वोट हम कह रहे थे कि नहीं, ये कोई भी नहीं है, ये नेचुरल सन ही नहीं है, इनका कोई राइट ही नहीं। आज के समय में अगर इसको मान लिया जाए कि हाँ ये इनका राइट होगा और ये बायोलॉजिकल सन है, तो इनका जो भी शेयर होगा उतना बराबर मेरा भी तो होगा।
ठीक है, पार्टीशन सूट फाइल किया, क्या फाइल किया?
नहीं, ये तो टाइटल
सूट फाइल किया,
तो हमारा टोटल सूट तो नहीं ना डिसमिस करेंगे।
तो आप हैं हावड़ा को रिप्रेजेंट करते हैं आप?
हम तो सर्वा को रिप्रेजेंट करते हैं, डिपेंडेंट हावड़ा हम लोग को करते हैं।
अच्छा, डिपेंडेंट उसको करते हैं, ठीक है। तो आपका सूट, आपका रिलीफ क्या था बताइए?
हमारा रिलीफ डिक्लेरेशन ऑफ टाइटल and confirmation of possession, and if found disposal, then recovery.
We lost under 71A also.
हाँ, एक बार हम लोगों ने एक पिटीशन लाया था, उस पिटीशन पर टाइटल के इशू के आधार पर उसमें डिक्लाइन हुआ था, तो बाद में हम लोग इसमें शुरू।
तो आपका रेस्टोरेशन तो डिक्लाइन हो गया था ना?
हाँ, वो हुआ था कि नहीं इशू ऑफ टाइटल
मेंटेनेबल नहीं हो?
हाँ, ऐसा है, क्योंकि दोनों पार्टी इसमें तो शेड्यूल ट्राइब, तो दोनों पार्टी शेड्यूल ट्राइब हैं, तो उसके लिए इशू ऑफ टाइटल कैसे डिसाइड करें?
Essay number 446 of 2017. The Learned Counsel for the appellant has referred to the genealogical table as mentioned in internal page 3 of the trial court's judgment, and has submitted that the case was filed stating that Hilda Oraon was the common ancestor who had only two biological sons, namely Sarua Oraon and Joshua Oraon, and one Harua Oraon was not a biological son. Hawaru. Oraon is not a biological son and was not entitled to inherit any property of Hela Oraon. He submits that it is not in dispute that the property was recorded in the name of a common ancestor, namely Hela Oraon. वही थे, उन्हीं के नाम से प्रॉपर्टी रिकॉर्डेड है।
सरवा के नाम से है, जुआ के नाम से है।
अच्छा, he submits that the property was recorded in the name of Sarua Oraon and Joshua Oraon.
Yes.
And the name of Harua Oraon was not mentioned.
Yes.
Correct?
Yes.
The learned counsel submits that
Suit land, not mentioned in the suit.
Not mentioned in the suit land. The learned counsel submits that the plaintiffs were the descendants of Sarua Oraon. Sarua Oraon had filed the suit. No? Sarua Oraon had filed the suit, and after his death, he was substituted. The appellant is Harua Oraon, the descendant of Sarua Oraon. Okay. He has further submitted that the courts have held that Harua Oraon was full brother of Sarua Oraon, and consequently Hela Oraon had three sons, namely Sarua Oraon, Joshua Oraon, and Harua. The learned counsel submits that in the aforesaid factual background, the descendants of Sarua Oraon were entitled to at least 1/3 share of the entire suit property. But the learned court has dismissed the suit in entirety. The appellate court has confirmed the judgment, and therefore a substantial question of law be framed as to whether the plaintiff is entitled for at least 1/3 share of the suit property, Schedule A and B.
Schedule B.
Schedule A and B both. Yeah. Considering the aforesaid submission, this appeal is admitted for hearing on the following substantial question of law.
time frame that keeping in view that he was a biological son, plaintiff is at best entitled to one third share, and the suit ought not to have dismissed in intact.
Sorry?
Suit should not have been dismissed in intact.
Whether the suit could have been dismissed in entirety without considering the claim of one-third share of the plaintiff over the suit.
After holding that he was a biological son.
That's it. I've already said that it is suitable. That's all. Issue notice to the respondents for which requisites issue notice to the respondents to the concerned police station for which requisites were filed within a period of 1 week. The records have already been received. Jim. Post on 26 November. So, and supplementary purpose.
Item 26, second appeal 67 of 2022.
उनका कोई एडवांस नोटिस आया? बिना एडवांस नोटिस के नॉट होगी। लास्ट टाइम आपका ऑलरेडी हो चुका है। थोड़ा बहुत से तो सब्सटेंशियल क्वेश्चन ऑफ लॉ नहीं बनेगा ना?
इसलिए हम बोल रहे हैं इसको सीनियर का पर्सनल
नहीं ऐसे नहीं होता है। क्या सूट था आपका?
हम सूट नहीं किए वो
सूट क्या था बताइए?
वो टाइटल सूट फाइल हुआ था, टाइटल सूट डिसमिस हो गया, उसके अगेंस्ट में अपील किया, अपील अलाउ हो गया, अपील के अगेंस्ट में हम आए। केस ये है कि रंगू और राम दो भाई था।
नहीं ऐसे नहीं।
प्लेंटिफ का जो केस है
कौन है आपके सीनियर? उनका तो बार बार आ रहा है एडजर्नमेंट नोटिस, लगता है बाहर है।
हाँ वो कुछ प्रश्न उनकी मदद कोई ओरल एविडेंस, कहीं कोई एविडेंस नहीं है कि राम और रघु दो भाई थे। उसी का ये केस है। लास्ट सर्वे सेटलमेंट में मेरा नाम, पर्चा में मेरा नाम, खतिया में मेरा नाम था। बाद में जाके क्लेम कर रहे कि वो राम और रघु दोनों भाई थे। उतना ही इस ओरल एविडेंस के आधार पर अपलेट को डिस्को अलाउ किया। जबकि एक नीचे जो सूट फाइल के थे रिस्पोंडेंट्स को 76 में कंक्लूड है, पेज नंबर 75 में। वादी की ओर से ऐसा एक भी दस्तावेज प्रस्तुत नहीं किया जिसे दर्शाता हो कि सुजन लाइबिलिटी का चूंकि विधि
दस्तावेज के बिना कोई प्रूव नहीं कर सकता कोई किसी का भाई है। ओरल एविडेंस है ना? ओरल एविडेंस भी नहीं है। There is no oral evidence that they are full brothers. सोच लीजिए।
इनके पोजीशन में आता है एक डिस्प्यूटेड लैंड, तो वो फिर सूट
आपके सीनियर कब आ?
नेक्स्ट देंगे हम इस पर वीडियो को खुद कर लेंगे। हम नहीं आए नहीं है, हम करेंगे इसको।
Essay number 67 of 2022. Council Pratap Pinat is present and is seeking time. On the last occasion, the case was adjourned by way of last chance. No advance notice has been circulated. However, in order to give one more chance to the applicant, let the matter be posted on. आज कितने तारीख है? 13th of November, subject to payment of cost of ₹1. Cost जमा करिए. If the receipt regarding cost is not deposited in the registry, this appeal will stand dismissed without further reference to it. 13 तारीख को 1000 रुपये कॉस्ट, वो एडवोकेट क्लर्क एसोसिएशन आपके एक पॉकेट से दूसरे पॉकेट में डालिए, जमा कर दीजिए।
Item 27, second appeal 69 of 2022.
Yes, appellant.
The appellant number is defendant number 1, Soma Kumar. Now there are 3 defendants number. Defendant number 1, Soma Kumar, number the appellant number. It's a concurrent findings of that. There are 2 plaintiffs. Both of them are brothers, Nilamar Singh Munda and Vishwadev Singh Munda. Both of them are the sons of late Bhutnath Munda. Now, the plaintiffs instituted the suit by filing the plaint, and they have prayed for a declaration of their right title and interest over the lands in question, and also for a decree for conference of their possession, and also if they are found not to be in possession over the lands in question, possession be restored in their favor. Now, the description of the land is that it's a plot number 82, khata number 23, Maja Pista Hatu, Araki district, Uti, and total area 8 decimals. And the most important thing is that they say in their pleadings that the recorded deed of which lands are Ustam Mundari and Guru Mundari. Guru Mundari died issueless. Ustam Mundari's son is Bhutnath Mundari, and from Bhutnath, these plaintiffs are claiming the lands in question, so they are claiming the lands in question on the basis of succession. Lord, by way of documentary evidence, Lord, the plaintiffs have brought on record only one exhibit, that is the Khatiyan of the land in question, showing Usta Mundari, that is the grandfather of these plaintiffs, to be the recorded tenant of the lands in question. Now, the specific case.
Plaintiff was claiming on the basis of hukumnama.
Lord, we have been claiming on the basis of the hukum.
Yes.
Now, Lord, what they say, that the nature of the land is coming in question. So it's a settlement, Lord, done by the village landlord in favor of the grandfather of the plaintiff. And they have also said specifically that they are paying rent to village landlord. Now, Lord, in response to the notice, Lord, the defendants are here, and the case of the defendants are that in the year 1945 itself, Lord, one hukumnama, Lord, was executed by Bhutnath Mundari. Bhutnath Mundari, Lord, happens to be the father of the plaintiffs. In the year 1945, Lord, on the basis of hukumnama, we are saying that, Lord, we have the occupancy right. And by virtue of the law of adverse possession, since, Lord, we have been holding the land in question right from 1945.
You can't have both, no?
Lord,
Either you will have title or you
no,
will
Lord,
have adverse
Lord,
possession.
it's not the case that, Lord, we have the title. Lord, what I am saying, Lord, I have 3 points.
Defendant is claiming by virtue of hukumnama, no?
Lord, I have 3 points to canvas. Lord, the findings are these. Now, Lord, the findings are important. Both the courts below, Lord, have said that the defendant has not been able to show even a single provision of law under Chotanagpur NCI, Lord, which says that a Raiyat, Lord, can settle the land in question in favor of another Raiyat. It is only the village landlord who has the right and the jurisdiction, Lord, to settle the land in favor of another Raiyat. It is not the Raiyat who will settle the land. Lord, I have a judgment of the division bench of our own High Court which says that a Raiyat can settle the Kami holdings in favor of another Raiyat, that is called, Lord, the Raiyat. It's another class of Raiyat, Lord, which has been carved out under CNT, and, Lord, I will be showing that judgment. But before coming to that point, Lord, the most important thing, Lord, which I consider, Lord, admittedly, Lord, this land belongs to the village landlord. It's a Kami holding. Lord, Kami holdings means, Lord, that the village landlord, Lord, has settled this land in favor of the grandfather of the plaintiffs only for the purpose of cultivation. Lord, title has never been conferred. The land has never been vested in the state. It's not a state settlement, rather it's a settlement of village landlord. So, Lord, I am putting a question to myself, unless and until, Lord, the village landlord whose successor is still living, and it has come in the evidence, Lord, unless and until, Lord, they are not made as a party, Lord, how the plaintiffs can claim title over the land in question as against me? Lord,
Who are you?
Lord, I have.
You are the defendant?
Lord, I am the defendant.
Who are you?
Lord, I have been claiming the land in question. Lord, I am only claiming, Lord, occupancy right. I am not claiming title over the land in question. And I have been claiming occupancy right on the basis of Hukumnama of 1945. But the plaintiffs are claiming the land in question, Lord. They are claiming the title without making the title holder as a party. And the title holder, Lord, admittedly Kartik Singh. This will be evident from the Khatiyan itself. Lord, without making him as a party. Lord, this suit is not maintainable. Lord, this is my first point. Now, Lord, my second point is that this finding of both the courts below, that there cannot be any settlement by a Raiyat in favor of another Raiyat, Lord, that runs counter to this judgment. Lord, if losses, if I may show the findings of the court. Para 14, internal page 8.
You have not acquired any right title interest in
But I have
connection
never
with
been
the property.
claiming about any right title and interest. Lord, my
Right title and interest means possession also.
Lord, I have been
It
saying
is not your suit.
Lord, it's not my suit. Lord, I have been saying that the father of the plaintiffs, Lord, had given me the occupancy right.
No,
And
you
right
see,
from 1945,
anything, you see, he gave you occupancy right, hukumnama. Now, is it accompanied with any rent receipt? Is it accompanied by any further documents, or you just only have the hukumnama?
Lord,
Any
Lord,
right
Lord,
in
admittedly,
immovable property cannot be transferred through, even occupancy right cannot be transferred. Any right of immovable property cannot be transferred through unregistered document. Hukumnama is being acknowledged by the courts basing on the subsequent rent receipts, etc. issue, and that.
Lord, admittedly there is no rent receipt, but Lord, admittedly there is no rent receipt, Lord, on the part of the plaintiff also.
You forget about the plaintiff.
No, that judgment, Lord, that says,
Your possession you have not proved, isn't it?
no, Lord, I have
You have not
said it.
proved your
Lord, I have
possession.
pleaded, Lord, specifically. Lord, I have given evidence, Lord, specifically, and Lord, nothing has been elicited from my cross-examination that I have not been
No, we are
possessing the
not here
lands
to
in question right
reappraise the
from
evidences on
1945.
record.
Lord, simply because, Lord, I don't have any rent receipt.
Simply means what? Your document is unregistered. It's
Lord,
a
that judgment, Lord,
it's
in
a
that
scrap
case,
of paper.
Lord, that judgment, Lord, in that case also it was unregistered. So
So
that judgment which I am showing. And then, Lord, in that judgment it is said that the Rayyat settlement is permissible
your
by virtue of an unregistered document.
you claim, just a moment, you claim this hukumnama from the father of the
Plaintiffs.
plaintiff. Father of the plaintiff were the Rayyats.
Not from the landlord. Not sorry. They were the Rayyats.
Father of the plaintiff was the Rayyat.
And it was Kami settlement.
It was Kayami settlement. Now you are claiming the property from the father of the plaintiff on the basis of a hukumnama.
Hukumnama by saying that this hukumnama should be read in substance, not in form.
No, nothing.
And
It is not to be read at all.
Lord, in that judgment, Lord, it was unregistered document. Lord, the main point sought to the answer, Lord, if I may place it. Lord, para 2.
No, you just don't read it this way. You read the appellate court judgment.
Lord, para 14. Lord, para 14, Lord, page
No,
number
just
8.
a moment. You read para 3 of the appellate court judgment.
Para 3.
Yes.
Para 3 of appellate.
Yes.
Lord, brief facts of the case of plaintiffs. Lord, is that the ancestor of plaintiff were settled rulers of village Pista Batu under IPPS within Kupi district where they owned and possessed lands and land of Pata number 23, plot number 82, area 77 acres of village Pista Batu under IPPS. Lord, within Kupi district, fully described in the schedule at the foot of the claim and recorded in RS record of rights. Stand recorded in the name of Ustam Mundari and Guru Mundari, both sons of Mohan Mundari as Kambi holding, and they are all along in possession of what is same. It is the further case of the plaintiff that the RT Guru Mundari died issueless and heirless, but Ustam Mundar survived by him only son Bhutnath Mundari, who also died leaving behind the plaintiffs as heir and successor after the death of Bhutnath Mundari. Came over the possession of the suit land and they are enjoying all sorts of right and interest over the suit land, possessing the land without interruption and paying rent to village landlord. There is no document. It is the further case of the plaintiff that the defendant raised unfounded claim for the first time in the month of February 2013, came over the land and started to establish foundation of the house Then plaintiffs made request to desist unfounded claim over the suit land, but it did not take it. Thereafter, the plaintiffs knocked the door of the court of SPM by filing a proceeding under section 144 CRPC, which was numbered as such and such. And there the defendant claimed that his father owned the suit property by virtue of Sadhanapur Nama in the year 1952, executed by Bhutnath Mundari, father of the plaintiff, which is illegal and incorrect because Candy Rayat cannot execute Hukum Nama. And as such, defendant has casted a cloud over the title of plaintiff as neither the father of defendant nor the defendant was in possession of the suit. The plaintiffs pray for relief as on the adjudication of the plaintiff's right title and interest over the suit land described in the schedule of the claim, and a decree be passed for confirmation of their possession over the suit land. Alternatively, if it is found that the plaintiffs are not in possession over the suit land, a decree be passed for recovery of possession of the same in favor of the plaintiff by evicting the defendant therefrom, and a decree be passed for the cost of the suit. On the other side, the case of the defendant is that the suit as framed is not maintainable, and plaintiff has got no cause of action for the suit as suit is under law of limitation, waiver, stopper, and such and such. The suit is that for non-joinder of necessary parties. It is further case of the defendant that the defendant number 3, father of defendant number 1, acquired the suit land more than 65 years ago. The state Amit Kumar acquired by valid right title and interest in suit property by long and continuous possession against the whole world. In such situation, the present suit cannot proceed in the eye of law. It is further stated that Santar Puran acquired the land out of suit plot, just adjacent towards western side. Sohan Lohar, son of late Mansa Lohar, acquired the portion of land out of the suit plot in southern side of the land in question, and Govinda Lohar, son of such and such, also acquired this land out of the suit plot. They are all residents of village Istahatu under RPPS within 40%.
The validity of your Hukumnama has been considered.
Not considered, but considered the grounds we can be seen. Para 14 of the appellate court judgment. This point of
It's an
consideration.
invalid document.
It's an invalid document only because of the fact that Jamindar, who happens to be the Naval Kishore Singh, they have not settled the land in question in favor of the defendant. It is the Rayas who has settled, who has been settling the land in
What
favor.
judgment you are filing? Yes, I think.
Kindly see the facts of that case. The para 2, the
This is 171A.
What's the 70?
Yes.
This judgment.
Yes, this judgment.
What we need. Para
Yes.
2.
Yes, para 2, which is 71A.
Not 71A, but the question for consideration was that whether a Rayat in a Kami holding can settle the land in favor of another Rayat or not.
The point is,
of the court.
irrespective of that fact, the settlement is by way of Sada Hukumnama, and that document is of no use.
Here in that judgment also the document in question was unregistered. Here also the document is unregistered.
So,
Then in that scenario, the division will say that no, there is a separate class of Rayat which has been carved out within the meaning of the
but
provisions
it was
of
an
the
admitted
NDA.
fact that the settlement was through Hukumnama. Here they are disputing it.
No,
There is a dispute.
No, it
Plaintiff
is not
said-
the case of the plaintiff that the plaintiff's father did not execute the hukumna. But what they say that my father does not have the jurisdiction to settle the land in question. They have never said that yes, my father has never executed the hukumna. It is the positive case of the plaintiff that yes, my father has done so, but he has no jurisdiction to do so. And I am trying to show that there is a jurisdiction to do so by virtue of this judgment. I am arguing on the admitted fact. And here also, it's a case of unregistered document. Had it been a case of the plaintiff that my father has never executed, disputing, then the matter would have been otherwise. But the plaintiff said that my father has done so, but he had no jurisdiction to do so, but as I have just now read, while reading the case of the plaintiff. And I am not claiming right title and interest over the land in question, but then I have the occupancy right, and it matured to that of law of adverse possession. And these aspects have not been considered. Rather, a clear-cut finding has been given that it is only the village Jamindar who will settle, not the Raiyat. Since the Raiyat has settled, therefore your document is not a valid document. Now I am trying to assail and attack this finding by virtue of this judgment. This judgment will be clarified.
The case was primarily decided on the point of delay. Para 47.
This judgment, the relevant paragraphs are para 1 to 9, which speaks of the fact, and the findings are recorded in para 25, 28, 29, 36, and 37.
Para number?
Para 1 to 9, in order to understand what are the facts. Para 2.
No, that we have seen. Para 28.
Para 25. In the instant case, the Kani Rayas, by virtue of the settlement of the land made in favor of Manoni Ekka, created a subsidiary right under them called under Rayat. No provision has been brought before us to show that any provision of the CNT Act prohibits creation of under Rayati tenancy. This is my case. The father of the plaintiff has created a subsidiary right in my favor, and the status of mine is that of the under right. And then section 4 of the said act, and then paragraph 28, 29.
Show me that there is a finding that this under this Kayami is it was an admitted fact from the side of the plaintiff that this under Rayati right was created. So, where is the admission? There it was an admitted fact that it was created. Show me from this that it was an admitted fact. You say that it is an admitted fact that Hukamnama was executed. Show me. Show me from the facts of this case that Hukamnama was admitted.
Again, I will be reading.
Yes.
Relevant page is page number 3.
Yes, I am reading page number 3.
Filed a proceeding under section 1 equal number and there the defendant claimed that his father owned to suit property by virtue of Sada Hukamnama. So and so.
Defendant का बात नहीं करिए, plaintiff का admission लिखो.
And there the defendant claimed that his father owned the suit property by virtue of so and so, which is illegal and incorrect. Now this is what plaintiff says. As because Kami Rayat cannot execute Hukamnama and as such defendant has casted a plot. So now it is the admission on the part of the plaintiff that yes, my father has executed the Hukamnama, but he does not have the jurisdiction to do so. And this judgment I am showing to this honorable court only because of the fact that yes, the Rayati had the right to resettle. And a specific finding has been given that no provision of law has been shown that a Rayat can resettle the land in question in favor of another Rayat. It is only the village Jamindar who can do so. Therefore, this Hukamnama is an invalid document. This is the specific finding. And how can
where is that finding?
Notice that finding is page number 9
of the appellate court judgment.
of the appellate court judgment.
Yes.
Not, not, after 1239. But appellant Soma Kumar had also admitted the evidence in para 28 of his cross-examination that Bhutnath Singh Munda was not the Jamindar. Rather, Naval Kishore Singh Munda.
You read para 14. This point for consideration.
Not this point of consideration and determination is related to issue number stated and decided by learned court below in favor of plaintiffs. Regarding these issues, respondents pleaded that the suit land pertaining to such and such has been recorded in the name of Ustam Mundari, and the respondents are legal heir and successor of the recorded unit, which is evident from Exhibit 1, that is the Khatna, adduced on behalf of plaintiffs for which the appellant defendant have not raised any objection, neither adduced any evidence, oral or documentary, to disprove the right address in possession of the plaintiff respondent over the suit land. Exhibit 1 and 2 adduced on behalf of plaintiff respondents also proved and established the aforesaid their claims. The defendant pleaded that his father got the suit land on the basis of Hukumnama dated 20.10.1945 executed by Gurnath Munda in favor of Amin Kumar, father of defendant number 1, and Amin Kumar, father of defendant, came in possession over the same, and after the death of said Amin Kumar, his son Soma Kumar, defendant number 1, is coming in continuous possession. The defendant produced Sada Hukumnama as Exhibit A. From perusal of the said Sada Hukumnama, it is evident that the said Sada Hukumnama is an unregistered document executed by Bhutnath Munda, which is Hukumnama Bandobast forever, and rent had been fixed 6 anna, and for the consideration amount of rupees 400 for the land of 8 decimals. In this regard, Soma Kumar has deposed during his evidence in para 28 that he got knowledge regarding the aforesaid Hukumnama in the year 2013 because by his son of defendant number 3. Appellant Soma Kumar has also admitted in his evidence that Bhutnath Singh Munda was not the Jamindar, rather Naval Kishore Singh Munda and his brother are Jamindar of his village and he is not paying rent to them. In para 27, he clearly stated that his father purchased on consideration amount of rupees 400. DW2 examined by appellant accepted in para 4 that Bhutnath Singh Munda had given a portion of land to appellant's father to support him with mercy for residence. The appellant had specifically stated that the Hukumnama was executed by Bhutnath Munda, but the defendant had not been able to show. Now, this is important finding. Under what provision of law, other than Munda, public Jamindar could execute or issue Hukumnama when the executor of the Hukumnama, Bhutnath Munda, was not Jamindar of the village in which suit land is situated. Now, this is the finding lot which runs counter to it.
Essay number 69 of 2022. For the learned counsel appearing on behalf of the appellant, this appeal has been filed against the judgment dated 25/2/2022 within bracket decree dated 10/3/2022 bracket close passed by learned Principal District Judge Kuti in Civil Appeal number 18 of 2018, confirming the judgment and decree dated 24/9/2018 and 1/10/2018 respectively, passed by learned Civil Judge Junior Division within bracket Munsif bracket close Kuti in title suit number 9 of 2013. The learned counsel for the appellant has submitted that the plaintiffs were the recorded tenant in connection with the suit property, and the defendants claimed the suit property by virtue of Sada Hukumnama dated 20/10/1945 issued by the father of the plaintiff. He submits that the learned court has rejected the claim on the basis of Sada Hukumnama dated 20/10/95 on the ground that the defendant has not been able to show any rent receipt pursuant to the execution of Sada Hukumnama. On the ground that the defendant has not shown any provision of law by which. What's the paragraph?
It's the page number 9, last portion. Page number 16 of the brief, internal
Yes.
page number 9.
Has not been able to
show under what provision of law, Mumbai,
has not been able to show under what provision of law other than Munda / Zamindar could execute / issue hukumnama when the executor of the hukumnama was not the Zamindar of the village. The learned counsel has referred to the judgment passed by this court in the case of Godwin Ikka versus State of Bihar. Reported in bracket 2009, bracket close 57, BLDI 2459. In LPA number 61 of 2004, decided on 3/3/2009, arising out of a proceeding under section 71 of the Chotanagpur Tenancy Act, and has referred to paragraph 25 of the said judgment and has submitted that there is no provision to show that there is no provision under Chotanagpur Tenancy Act which prohibits creation of under Rayati tenancy. He submits that in the said case also there was Kayami Rayati by virtue of settlement, who in turn created an under Rayati tenancy. After hearing the learned counsel appearing on behalf of the appellant, this court finds that the specific case of the plaintiff was that ancestors of the plaintiff had settled Rayat with respect to the sued property and were having Kayumi holding the recorded tenant was Guru Mundari, who died issueless and heirless, but the recorded tenant was Pustam Mundari and Guru Mundari, both sons of Mohan Mundari as Kayami holding, and they were in possession, and the plaintiff was the recorded tenant. Guru Mundari died issueless and heirless, but Pustam Mundari was survived by his only son, Bhutnath Mundari, who also died leaving behind the plaintiffs as heirs and successors. And they claimed to have been in possession of the property. A proceeding in the month of February 2013, the defendant came over the land in February 2013 and started excavating foundation of a house, and ultimately a proceeding under section 144 CRPC was initiated, which was numbered as miscellaneous case number 22 of 2013, and the defendant claimed that the father of the plaintiff had issued Sada Hukumnama in the year 1952 the case of the plaintiff was that the claim was illegal and incorrect, also because Qayyami Rayyat cannot execute Hukumnama, and a cloud was created in the title of the plaintiff, and consequently the suit was filed. So far as the defendant is concerned, they contested the case on the point of limitation, adverse possession, on the point that the suit was barred by limitation, waiver, estoppel, acquiescence, and barred under section 34 of the Specific Relief Act, and also for non-joinder of necessary parties. And they claimed that the land recorded under Khata number 23, plot number 82, area 0.30 acre was already conveyed or transferred by Bhutnath Mundari, the father of the plaintiffs, to different persons, including Amin Kumhar, son of Guru Kumhar, father of defendant number 1. And they also claimed adverse possession. They claimed that they had acquired title with respect to the suit property since the year 1945. Hukumnama is dated 52. Since the year 1945, when the Hukumnama was executed. The learned trial court framed the following issues for consideration. By deciding issue number 7, which is the bone of contention, the learned trial court considered issue number 7 and 8 together. And ultimately held that the landlord had settled the land in favor of deceased father of defendant number 1, was not valid in the eyes of law, the transaction was held to be void ab initio. The Sada Hukumnama was declared to be an invalid document. And ultimately the suit was decreed. So far as the learned first appellate court is concerned, the appellate court while considering the point of determination number 3 and 4, while considering the point of determination number 1, has considered the legality and validity of the claim of the defendant on the basis of Sada Hukumnama dated 20/10/1945. The learned first appellate court held that the defendant claimed that they had claimed the property on the basis of Sada Hukumnama dated 20/10/1995, but has not been able to show under what provision of law other than Munda/Jamindari could execute the Hukumnama. The defendant was also not able to show any rent receipt issued pursuant to the execution of the Sada Hukumnama. The court also recorded that unregistered Sada Hukumnama can be used for collateral purpose, but in this case, the Sada Hukumnama was issued by the tenant and there was no rent receipt on record issued by the competent authority. And ultimately held that the Hukumnama dated 20/10/1945, on the basis of which the defendant claimed their title, was an invalid document and no right, title and interest could pass to the transferee pursuant to the Sada Hukumnama, and decided the issue number and held that the issue number 6, 7 and 8 was rightly decided by the learned trial court. This court finds that the plaintiff had questioned the legality and validity of the Sada Hukumnama, which was relied upon by the defendant to claim right, title, interest and possession. It is not in dispute that the father of the plaintiff was the recorded tenant, and the defendant claimed that the recorded tenant had issued the Sada Hukumnama to the ancestor of the defendant. The argument advanced by the appellant by referring to the judgment passed in the case of Godwin Ikka to submit that there is no legal bar in Qayyami Rayyats making settlement under the provisions of Chotanagpur Tenancy Act, and his specific argument is that such settlement could have been made by the father of the plaintiffs. This court has gone through the aforesaid judgment and In paragraph 30 of the said judgment, it has been held that in paragraph 32 of the said judgment, it has been held that creation of under rayati tendency and customs of acquisition of right even similar to those of an occupancy rayat could not be said to be in violation or inconsistent with any other provision of the Act, and that it is different question that in all cases an under rayat does not acquire occupancy right in the land held by him. Acquisition of such a right is subject to custom or usage prevalent in the area. The claim of such custom raises a factual question and the same is required to be pleaded and proved. And ultimately the judgment passed by the Honorable Division Bench was decided by observing that the provision that Section 71A was invoked after lapse of inordinate delay of 43 years. And the appeal was allowed. This court is of the considered view that in the instant case the defendant was claiming right title interest with respect to the property on the basis of Sada Hukumnama executed by the tenant, but the same was not supported by any proof of his occupation of the suit property, including any rent receipt, etc. The learned courts have taken a plea that the plaintiff neither could show as to under what provision the Hukumnama was executed by a Rayat, nor could show that they acquired any right title of an interest and possession by virtue of the Hukumnama, Sada Hukumnama dated 20/10/1945. The court has also taken into consideration that Sada Hukumnama could be used for collateral purpose but in the present case, Sada Hukumnama was issued by the tenant and there was no rent receipt on record issued by the competent authority. This court finds that the defendant claimed right only on the basis of Sada Hukumnama and the same being unregistered could not have been recognized by law. The plea of adverse possession has also been rejected by both the courts by observing that the defendant has not been able to show his possession of the pursued property. And the defendant all of a sudden in 2013 started claiming the suit land by digging it for construction of building. And the witnesses examined on behalf of the plaintiffs substantiated the claim of the plaintiff that the defendant was never in possession of the suit property. This court finds that there is no illegality or perversity. This court finds that no substantial question of law arises for consideration in this appeal, which is accordingly dismissed.
From supplementary list and rating for orders, item 5, second appeal 2/06/2018.
One IA has been placed before of signal. That is IA number 7014 of 2025. What happened in this IA I have given in exhaustive facts, the pro forma respondent number 3, 5 and 6. They were the pro forma respondents in the title appeal, but the plaintiffs. Now it is a second appeal by the defendants against the plaintiffs lost in this suit. Thereafter in appeal it was reversed. Now your lordship may kindly see, I have given word on second appeal notices were issued. There are 5 notices were taken again. There are 6. The service report upon the pro forma respondent number 3, 5 and 6 reported that they have died. Now, in terms of order dated 21st of March 2025, press notices were issued to the respondent court. Then general paragraph 8. The appellant number 1 made inquiry about death and it has been found that para 9, 10 and 11. Para 9 were Juman Mia.
When were they reported to be dead? In which order?
The
3, 5 and 6?
3, 5 and 6 were 21, 3, 2025.
No, in which order they were reported dead?
Or in the service report.
So what is the date?
So date 21st March 2025. Sorry, yes, it was 21st March 2025. Oh, sorry. Yes, 16/4/2025. 16/4/2025.
No.
The
The appeal awaited against respondent number 3, 5 and 6, no?
Yes, sir.
3, 5 and 6, it has been recorded on 17/8/23.
So 17,
17/8/23.
20. So,
Right? The fact that it has abated has been recorded on 17/8/23.
2023.
Yes.
Now, thereafter, the appellant number 1 inquired about their date of death and the
No,
areas
just a moment.
because they were not the parties to the along with this appellant. Appellants are the defendants. And you will also may kindly see for a moment the memo, the decree in appeal under Chennai.
No, what did you do so far as 23 till 25? आप क्या किए?
23, yes.
Yes.
21/3/2025.
17/8/23 के बाद आप क्या किए?
17/8/23 के बाद जो पता लगा उनका
कहाँ पे कुछ भी आप नहीं
degree
लिखे।
was against a dead person. It is a nullity. The decree was passed against a dead person.
When did they die?
They died not during the pendency of the appeal, title appeal. That I have stated categorically, not
कहाँ
and
पे
it is a
बताइए?
fact. Your Lordship may kindly see.
There were 3 persons, no?
Yes, 3 persons.
तीनों during the pendency of.
Yes. Your Lordship just see para 9. The appellant number 3 died in 2008. Para 10.
So trial court, what is the date of trial court decree?
Yes. Judgment, appellate court judgment.
Trial court.
Yeah. Trial court decree was 9/7/2026/6/2007.
26/6/2007.
Suit was disposed of.
Appellate court decree?
Now, appellate court decree is not 4/9/2017. So in between they died.
Just a moment.
Yes.
Juman Mia was the
Died in 2008.
2008. He was the respondent in the first appeal, or
Yes, sir. That is the reason I was referring to in page 12 of the memo of appeal, that is the judgment. Names are there. Juman Mia was respondent number 10. Respondent number 10.
Juman Mia was son of
Juman Mia,
Ramjan Mia.
Muslim, all are
Just a
sons of
moment.
Ramjan Mia.
That's right. So appellant is also the son of Ramjan Mia.
Therefore,
Full brother.
in suit, yes, full brother. They
Yes,
did not
full
take any
brother.
step.
You did not take any step.
I was not the appellant. I was the, we were respondents number 1 to 9 in the appeal, page 12. 1 to 9 were the respondents, contesting respondents, and we have prepared the second appeal.
Okay.
So, but 10, 11, and 12 are concerned, they are the pro forma respondents in the appeal, title appeal, where the present respondent number 1 and 2
So
were
they
there.
did not take any steps.
Yes, respondent number 1 and 2 did
Now,
not take.
respondent number, that is Yaqub Mia and Rafiq Mia, they did not take any
They
steps
did
for
not take any
substitution.
step, yes. That I have stated in my petition.
Okay, so the first therefore the first appellate court,
Passed a decree
Ag-
against the dead person.
no, they are just pro forma
They are the
defendants.
pro forma.
They are a pro forma.
This is the fact. No? Now, Lord, I have stated no, during the pendency of the appeal, they died. After the suit was dismissed.
Only one Juman Mia had died.
All the three. They were just in 9, 10, and 11. 9, I have stated, Lord, that Juman Mia died in 2008. So far, Lord, 10
Muslim Mia also died.
died in the year on
Basid Mia.
16/3/2008.
Okay. Basid Mia also died.
Muslim Mia died on 3/11/2010.
Okay.
And Basir Mia will be respondent number 13 in the appeal, 16/3/2008. So, 2 persons in 2008 and another is 2010 during the pendency of the appeal, title appeal. And that judgment is under sale.
IA number 7014 of 25. The learned counsel for the appellant has submitted that Jumban Mia, Muslim Mia, and Basir Mia,
Yes.
who are pro forma, respondent number 3, 5, and 6.
3 finals.
Died on in the year 2008, comma
3/11/10
3/11/2010 and 16/3/2008 respectively, during the pendency of the first appeal. The learned counsel submits that the appellants before the first appeal did not take any steps for substitution, and consequently the appellate court's judgment and decree has been passed in connection with persons who were already dead.
And respondent 1 and 2 received the notice, but they did not appear till date. That is recorded in the orders. Even
The learned counsel submits that
proposed
the
legal heirs
appellate court's judgment was passed.
on
Just a minute. Was passed on 4th of September 2017.
2017.
He submits that on this score itself, the appellate decree cannot survive. However, he submits that notices be issued to the proposed legal heirs and successors for passing appropriate order.
Office note says not that they have received.
They have received.
Track record, yes, track record. The office note today's
The learned counsel submits that the legal heirs and successors of the proposed legal heirs, the legal heirs and successors of 3, 5 and 6 have already received.
Now, as per the track report, it has been served.
As per the track report or speed post, the notice has been served but nobody has entered appearance. He submits that the interlocutory application be allowed. Considering the aforesaid submissions and the amendments made in the interlocutory application, that Ruman Mia, Muslim Ansari लिखे हैं,
Muslim Mia and Basir. All are sons of Ramlan.
10 में 4 नाम लिखे हैं, all 3 sons of Muslim Mia, Muslim Ansari लिखे हैं. पैरा 10 में देखिए ना, मुस्लिम अंसारी लिख दिए. And Basir Mia on 16/3/2008. The interlocutory application seeking substitution is allowed after setting aside the abatement and condonation of delay. However, it is to be considered as to whether the appellate judgment and decree passed by the first appellate court would survive on account of the fact that the aforesaid respondents had died during the pendency of the first appeal.
There was an interim order on 11/9/2025.
इसमें अभी कोई क्वेश्चन ऑफ लॉ नहीं बना है.
नहीं, अभी तो लिमिटेशन पर काम नहीं है.
लिमिटेशन पर ही चल रहा है.
117 दिन का.
अब डिले भी कंट्रोल कर देते हैं तो क्या ही बचा. ये जो नोटिस हुआ था सब्स्टिट्यूशन क्यों हुआ था?
Substitute. That is IA number 11839 2023.
IA number 1839 of 2023 seeking condonation of delay
Of 117
of 117 days in between the appeal. Is also condoned. Is also allowed.
Yes.
5, 6.
You will register.
Respondent number 4 का क्या हुआ?
इनका भी सर्विस भी तो रहा है ये रिसीव रेस्पॉन्ड नंबर 4 ट्वाइस नोटिसेस रिसीव लास्ट
फ्रेश नोटिस बार लिमिटेशन पे जा रहा है.
ऑफिस नोटिस 1 2 and 4
Sir, as per order dated 16th April 25, the notice has been validly served upon respondent number 1, 2 and 4. But nobody has entered
nobody
appearance.
has
Nobody has entered appearance. So delay भी आपका हो गया?
जी for admission
Office is directed to place this case under application in the next week.
only the interim order otherwise notice to till date 11/9/2025 11/9/2025
The interim order dated 11/9/25 is directed to continue till 26 November post on 26.
ऑर्डर्स का पीरियड 14 है अगर कोई सप्लीमेंट्री में आती है
क्या?
उसमें पेपर क्वालिफिकेशन का माइनर प्रॉब्लम आता रहता है कि कंप्लाई विद फाइल पेपर कटिंग ऑफ दिस पेपर इन कंप्लायंस ऑफ
So substituted service is complete.
यस
Entire service is complete. Has anybody entered appearance?
no one has entered again and state के तरफ से I will serve also copy because no one name of any state council is not active.
You must have served. Have you not served?
No, it was notices were issued madam. Only for 3
For
and
substituted service of 3 and 4.
yes, like mine.
Okay. What about others?
1 and 2 they are the state authorities. Notices are issued to all madam because it's going to be matter of deputy commissioner of Jharkhand.
Service is complete. 3 and 4
Complete,
का.
yes. But fair on fair side madam, I must be directed to serve a copy to the office of the AG madam.
Notice number 1 and 2 is found validly served.
Yes, sir.
Or here also.
Yes.
Okay, FA number 138 of 2023. As per order dated 28th of June 2024, notice upon respondent number 1 and 2 was validly served. So far as respondent number 3 and 4 are concerned, the council has submitted that he has filed supplementary affidavit bringing on record the substituted service of notice through newspaper. एक ही पेपर में
The
था?
दो पेपर टेलीग्राफ एंड टाइम्स ऑफ इंडिया
दोनों इंग्लिश?
दोनों इनको कनाडा का है इससे टेलीग्राफ कहते हैं रिपोर्टर
The substituted service, the service of notice upon respondent number 3 and 4 is also accepted through newspapers. अब
अभी की टेलीग्राफ पर गए
finally
यस
क्या मैटर?
matter specific performance of contract assumed has been dismissed and it has come in the judgment that we have already given 48 lakhs out of the total consideration amount of
The matter arises out of specific performance of contract. Records आ गए? क्यों? Records क्यों नहीं है? NCR kept below.
Section में
Section. Pose this case for final disposal on Tuesday in the supplementary cause list. Counsel for the appellant shall also serve a copy of the memo of appeal, 2 copies of the memo of appeal in the office of learned advocate general. वैसे तो complete है, लेकिन फिर भी आप serve कर दीजिए.